Well, good afternoon, everyone. On behalf of the Jacksonville Lawyers Chapter of the Federalist Society, welcome to today's webinar. My name is Patrick Kilbane, and I serve as the president of the Jacksonville Lawyers Chapter. And on behalf of all of our members, thank you so much for joining us today. There's a lot of interest in today's webinar, so I'm going to keep my remarks very brief. We've got nearly 350 registered guests, including non-members and some members of the media. So for the non-members, we hope that you'll thoughtfully consider joining the Federalist Society. And for those of you who aren't familiar with the Federalist Society, we're a network of lawyers that believes that the separation of powers is central to our government and that it's expressly the province of the judiciary to say what the law is and not what it should be. Our esteemed panel of jurists today are going to talk about those topics and more. But before I introduce them, I wanted to say a special thanks to Alessandra Cruz, who is the Assistant Director for the Lawyers Chapters of the Federalist Society. She's been extremely instrumental in setting up the technology and getting us all set up today. So, Alessandra, thank you very much. We appreciate all your help. And now for the introduction of our three panelists. First, I'd like to introduce the Honorable Amy Coney Barrett. Judge Barrett was appointed as a United States Circuit Judge in 2017. She went to law school at the University of Notre Dame, where she graduated summa cum laude, and she received the law school's Hoynes Prize as the top graduate. She was also a Kiley Fellow, and she was the executive director of the Notre Dame Law Review. When she graduated, she clerked for the Honorable Lawrence Silberman on the DC Circuit, and of course was a law clerk to Associate Justice Antonin Scalia at the United States Supreme Court. After she got done clerking, she worked at the Miller Cassidy firm, litigating complex criminal, constitutional, and civil cases. She had a lengthy career as a full tenured professor at the law school at Notre Dame, where she's still teaching. In fact, she's already started the fall semester. And from 2010 to 2016, she served by appointment of the Chief Justice of the United States on the Advisory Committee of the Federal Rules of Appellate Procedure. Judge Barrett, I thank you so very much for joining us today. I actually had the pleasure of being her student twice, and we've remained friends all these years, and I know I can take a point of personal privilege to say that whenever there's a vacancy on the Supreme Court, I know I'm rooting for you and a lot of other people are. So thank you very much for joining us. Our next panelist is the Honorable Wendy Berger, who was appointed last year by President Trump to the Middle District of Florida. Judge Berger is a double Seminole, and she's not afraid to tell you that. Law school and undergrad at Florida State. And when she was at Florida State, she was also on the Law Review. Judge Berger has served our state in a number of amazing capacities. She started as an assistant state attorney and then went to work as deputy counsel for Governor Jeb Bush and was also his clemency aide. Then after her tenure in the executive office of the governor, she was appointed as a judge in Florida's 7th Judicial Circuit and then was promoted to the 5th District Court of Appeals, and now she serves as a federal judge for the Middle District. So, Judge Berger, thank you. Most of the people on the call certainly know you and are familiar with you, but I appreciate you joining us. Our third panelist is the Honorable Paige Gilman. Judge Gilman, certainly a rising star in our state judiciary. She's received 2 appointments from our governors over the past 2 years. She'll be transitioning to the 15th Judicial Circuit bench in January, and currently she serves as a Palm Beach County judge as the administrative judge in the civil division. Judge Gilman got her undergraduate degree and her law degree from the University of Florida. She also started her career as an assistant state attorney in Florida's 19th Judicial Circuit, and then litigated complex commercial and intellectual property matters for a period of time, and also served as staff counsel for Allstate, Esurance, and Encompass. And I want to say a special thanks to Judge Gilman because she really helped me put the substance of the program together. And last, but certainly not least, I want to introduce our moderator, Joe Jacquot, Jacksonville's own Joe Jacquot. Joe is the general counsel for Governor Ron DeSantis, and I bet if you asked him a year and a half ago if he was going to be a national expert on drafting executive emergency orders, he probably wouldn't have put that high on his list. But Joe graduated, he received his undergraduate degree from the University of Virginia, his law degree from the University of Florida. He served as a lieutenant in the United States Navy, deputy chief counsel for the Senate Judiciary. He managed the confirmations of the Chief Justice John Roberts and Associate Justice Samuel Alito. And then he became the Chief Deputy Attorney General for the state of Florida. He initiated the 26th state litigation for the Affordable Care Act. And he also argued successfully before the United States Supreme Court in a Miranda rights case. Many of you are familiar with Florida versus Powell. Then Joe worked at a national law firm, which had an office here in Jacksonville, leading their national state's attorney general practice. And before that, he was an executive with a publicly traded mortgage company in Jacksonville. So thank you all so very much. I know there's tremendous excitement for the program today. And Joe, I'll pass the baton along to you.
Great. Hey, thanks, Pat. Thanks for putting this together. Thanks for your friendship. Well, let me note the title of our webinar today. Justice Kagan declared in a tribute to Justice Scalia that we're all textualists now. Now, certainly we count Justice Scalia as successful in persuading judges and lawyers to begin constitutional and statutory interpretation with the text itself. But once beginning there, there's a question of whether judges are actually sticking with the text. Are they deciding cases on the text? Are they faithful to the text in our constitutional structure? Well, those are the issues we're going to explore today. We're going to do that with specific topics on textualism, on originalism, and on the role of stare decisis. And then we'll save some time for Q&A. So let's jump right into it. I'll first ask our panel of rock star judges how each of them has transitioned into the current role that she has on the bench. So let me start with Judge Barrett. Can you tell us a little bit about how you moved from being a law professor to being a judge on the federal appellate court?
Yeah, thanks, Joe. I certainly didn't imagine that I would be in this position, but I really love my new job that I've been at for about 3 years now. I feel like many of the career experiences that I've had along the way have prepared me for this, and I can draw on my time as a law clerk and my time in practice, my time as a law professor, my service on the Federal Rules Advisory Committee for the Rules of Appellate Procedure, all kind of coming together to prepare me for what I do now. And as a law professor, which is where I spent the bulk of my career, law professors are about reading and writing. We're spending a lot of time, in the classroom and mastering material and teaching great students like Pat Kilbane. But, we spend a lot of our time writing law review articles as well. And it's a kind of a monastic life. You don't necessarily interact a ton with colleagues, especially in the summertime when people are working on research projects. And so all of that bears some similarity to the work of an appellate judge because it's a lot of reading and a lot of writing, and our chambers are all separate. I'm in South Bend. Many of my colleagues are in Chicago, the majority of them are, so there's not a lot of day-to-day interaction with the other judges, although there is with my law clerks, and that is definitely a highlight of the job. So much as I've had the pleasure of interacting with so many students over the years, now I get to do that same thing with the law clerks who are just beginning their careers, and I have the ability to train them. So, the transition, certainly there are new skills involved, and I really like being part of the justice system and doing work that matters to people in individual cases, to the litigants whose cases are resolved, whose claims are resolved, to the criminal defendants whose convictions and sentences are on appeal. That's very meaningful work, and so I really love doing it. And I've been able to keep my foot in at the law school. As Pat mentioned, I still teach, and I've now have a foot in both places. So I can keep my toe in over there, and I still teach a seminar each semester. And I've really loved that. The Seventh Circuit has a bit of a tradition of that. Both my colleagues, Diane Wood and Frank Easterbrook, remain on the faculty of the University of Chicago. So it's something, that academic experience is something that's valued on our circuit, which I greatly appreciate.
That's great to hear. And hey, thanks from all of us that you're still that engaged with young lawyers, with students. Building up a legal career with the right foundation is so important. So thanks for that. All right, we're going to move to Judge Berger. She has had a double transition from state to federal and from appellate to trial court. So tell us a little bit about that.
Certainly. First, I would say it's been an interesting transition. I've just come up on a year on the federal bench. For the last 6 months have been sort of in this COVID era of working remotely, having to conduct hearings telephonically or via Zoom. So it's been interesting. It's been an interesting last several months. But I've enjoyed the transition. One thing I missed, I enjoy the intellectual aspect of the law, and I very much enjoyed that on the appellate court. I like to read and write, and so that aspect of the appellate bench was very appealing to me, and I enjoyed it. But what I missed was being in court. I missed trial work, and so what I found transitioning back to the trial bench at the federal court is that it really seems to be the best of both worlds. I do have the opportunity to write, and in the state trial court, if there's a motion filed, you're typically going to have a hearing on it, on any motion that's filed, and it's just not the case in federal court. Much of what we do is based off of the briefings, and so that's very much like my work on the Fifth DCA. But to the extent that I am in court and trying cases and having hearings in certain cases, what I missed, I'm now being able to do again. So it's been an interesting transition, but I've enjoyed it.
Well, I know for a fact that there are some judges on the Fifth DCA that dearly miss you, but we're thankful to have you in the Middle District.
Thank you. I miss them as well.
Yeah. All right, well, let's go to Judge Gilman, who is planning her transition. You can talk a little bit about the timing of that and the process you went through and are going through to move from the county bench into the circuit trial bench in Florida.
Sure. So thank you again, Joe, for doing this today. We really appreciate it. So I was appointed by Governor DeSantis at the end of June of this year for a seat that is not actually available on the circuit bench until the very beginning of January 2021. So although I will be taking that role, I'm still serving in my role on the county bench. So it's sort of the best of both worlds, other than the being administrative judge right now during COVID has really presented some unique challenges. But I'm very happy that I can remain here and sort of see those through. Let's hope that it'll be through, at least in some capacity, by January. I didn't, at the time, didn't really see how it would be possible that as a county judge, I would be constantly looking for executive orders from either President Trump or Governor DeSantis to see if my day-to-day operations would be affected by that. So it's certainly been a unique 2020 in that way. But for as far as the transition to the circuit bench, like many, I went through the 15th Circuit Judicial Nominating Committee, was selected as a list of 6, which was then sent up to Governor DeSantis to be interviewed by Mr. Jacquot in his office for that appointment. So I'm very grateful for being here today, and thank you so much.
Yeah, well, we're very excited for you. So look forward to you getting on the circuit bench at the beginning of next year. Okay, so what we're going to do in walking through these three topics of textualism, originalism, and role of stare decisis is we're going to allow each of our judges to comment on each of those. So rather than maybe the normal format of 10 or 15 minutes per panelist, we're going to try to make it a little more dynamic and let them jump in. I'm just here to really prompt the conversation, but they can take it wherever they think it should go. So let me just start that prompting with Judge Barrett. And, it's always good to make sure that we're starting conversations on the same page. So maybe you can just tell us at some high level, what is textualism and why does it matter?
Sure. So I'll take the why does it matter first. I was actually in my statutory interpretation seminar that I taught on Monday, I was explaining to my students, I was putting the debate about statutory interpretation today in historical context. And really in the 1980s, when Justice Scalia first began giving lectures at law schools about statutory interpretation and writing a lot about it, there wasn't a lot, there were not statutory interpretation classes in law schools. Now legislation and regulation classes are a big part of the curriculum at many law schools, and that was not the case then. In fact, Justice Scalia could say, in his book, A Matter of Interpretation, I think is where he said it, that, it's a shame that judges don't have a theory about what they do most, which was interpreting statutes. So, back at that time, there was certainly a lot of talk about purpose and purposivism, and I would say that interpreting a statute consistently with its purpose was the predominant approach, even when that purpose or perceived legislative intent deviated from the text of the statute. But there wasn't a lot of academic commentary about it. It wasn't perceived as its own topic. There would never have been a webinar on it. It was not perceived as something independent for people to study as opposed to something that they just did in the course of, say, litigating a tax case or litigating a CERCLA case, cases in which statutes came up. So largely through the efforts of Justice Scalia, the theory of textualism emerged in the 80s and has now gained enough sway that, as I think it was Pat pointing out at the beginning, that Justice Kagan has said, we're all textualists now. The theory of textualism, I think, distilled down to a nutshell, is that it's the principle that words in a statute should be interpreted in accordance with their ordinary meaning at the time the statute was enacted. And I think that has two important parts that are worth highlighting. One is the temporal component, that the time that is relevant is the time of the statute's enactment. And that is so because that is the time at which it went through the process of bicameralism and presentment. It became law. And so the Congress and President who had the authority to enact this binding law, were at a particular point in time, and they were responsible to constituents who were there at a particular point in time. And so if we depart from that meaning and say, update the statute and look at more contemporary meanings of the words, then we are not being consistent with, what the legislators and those who would have read that text at the time would have understood those words to mean. The second component of that definition is ordinary meaning. And this is the principle that we look at how someone who was conversant in English language and with the relevant subject matter, what they would have understood those words to mean. And that stands in contradistinction to, say, the private intentions of the legislator, which at the time that Justice Scalia began writing a lot about textualism and speaking a lot about it, I would say that that was the competing approach. He focused on ordinary meaning because in many cases, courts were substituting private intentions of the legislator as expressed in things like legislative history. So they might say well, the statute says this, but we know from the committee report that what the legislators were really trying to accomplish was Y. And Justice Scalia's focus on meaning focused on the fact that it is the text and the text alone that has gone through the constitutionally prescribed process of bicameralism and presentment to become law. The private intentions of the legislators do not govern us. The written text does. So I think that's one thing, to distinguish between the ordinary meaning and the private intentions of legislators. And I think it's also important to distinguish between the ordinary meaning and the policy preferences of the judge. That the judge is bound to follow the statute where its text leads, even if that text leads to a place where the judge would prefer not to go, because that respects the role of Congress. If we're talking about the federal system, that respects the role of Congress as the lawgiver. And it's the task of the judiciary to apply the law as written. You know, there are a lot of disputes. I mean, saying we're all textualists now doesn't mean that every textualist will interpret a statute the same way. But I think that the conversation has changed a great deal since Justice Scalia first entered the scene and began talking about textualism. And the disputes are really no longer about, if you think about the big statutory interpretation cases that we've had in the last several years, they're really about what the text requires. They're not as much about whether private intentions of legislators or purpose should trump. So I think the debate has really changed, and it matters both because, I mean, I think it should matter to the litigators who are listening, because textualism is what a lot of courts are doing now. And so textualism matters to you because courts want to hear those arguments. And so you need to frame them well for your clients. I think textualism matters. I mean, I would say myself as a textualist, textualism as a theory matters because while Justice Scalia may have lamented in the 80s that judges have no theory of what they do most often, it's important. Judges have to be coherent. And so for me, textualism matters because it is a theory, one that I think is consistent with the judicial role under the Constitution of what I do quite often, which is interpreting statutes.
That's excellent. I'm going to ask you a second question based on something you mentioned, which is that, you know, there's a common understanding of, you know, what textualism is generally, or that people start with the text, but the secondary question is, what does it actually require? And so I want to just hear a little more about how you in practice carry it out, and specifically two ways that often come up in our conversations in our office, which is one, how do you decide whether a term is ambiguous even to start? Like, how do you move from just the plain and ordinary meaning to some other analysis? And then when you decide it's ambiguous, like, what's your go-to canon of construction? You know, how do you apply it from there?
Well, I think deciding when a statute is ambiguous, you know, is the big question. So when Justice Kavanaugh was Judge Kavanaugh, he wrote an article in the Harvard Law Review about that very issue. And he wrote this article saying that often is the fight, that threshold question, especially in the kind of cases that he saw in the DC Circuit when ambiguity triggered Chevron deference. So it was all about when was something ambiguous. And I think it's really difficult to say in the abstract when is a statute ambiguous, because every statute, you know, it's words. Every statute kind of turns on the words used in that statute. I think for me, it's not that I have a threshold level of like, how clear must it be clear? But if as a reader, you know, you apply the traditional tools of statutory interpretation, which would begin with what is the ordinary meaning of this language in context. And that doesn't mean the dictionary definition. I mean, dictionaries are important and all interpreters, not just textualists, use them. But dictionaries define words in isolation. They don't define words in context. And, you know, language is a social convention. We're part of a linguistic community. And so it's important to understand that words may vary depending on the company they keep, you know, the other words that are used in a phrase. So I think there are other tools like corpus linguistics is becoming, you know, a more and more common tool. It's a way to kind of go beyond the dictionary and look at how words are used in context. But I would say I look at the word, I consider the meaning of the word, I consider the context of the word. And in terms of what go-to canons are, I mean, I think that the so-called linguistic canons, which are the rules of grammar, nocere sosis, things like that, adjustum generis, I think those capture, in general, patterns of the way that we speak, and so they can be very helpful as first-order references. You know, like the Scalia-Garner reading law book steps through a lot of those canons. And that's not to say, and the Scalia-Garner book doesn't say that any particular canon always reflects how people use language. Sometimes a list isn't exclusive, right? Sometimes you specify a list, but in fact, it's not designed to define the universe. So I think the canons, the linguistic canons, can be a useful guide, but I wouldn't resort to the substantive canons, the ones that reflect policy goals, like say the rule of lenity, for example, unless after exhausting the traditional tools of statutory interpretation, which I take it to go more to the ordinary meaning, and that includes linguistic canons, context, definitions, etc. If that leaves me with ambiguity, then I would resort to the policy-based canons, which would be things like avoiding constitutional questions and the rule of lenity and that sort of thing. I think those come later. And that the Supreme Court in Kaiser versus Wilkie, when talking about our deference, Justice Kagan's opinion was very clear to say, we don't resort to our deference unless we have exhausted every tool of statutory interpretation first and are still left without a clear answer.
Yeah, good, thank you. All right, let me move to Judge Berger and ask you, so textualism, is it really just for judges or is it for lawyers too?
Well, I think in as much as the judge is the ultimate decision maker, that textualism is often defined as a judicial interpretive philosophy. But as it relates to counsel, I don't think we can discount the importance on focusing in their arguments on the text and what the fair reading of a particular text or statute or constitutional provision or contractual provision is when you present those arguments to the court.
So, for lawyers out there that are trying to figure out how they can make good textualist arguments, let's say they're in your court, what's some advice you have on ways to approach that?
Well, I think Judge Barrett outlined some of them when she was talking, but I think that in the absence of a binding precedent, because obviously I think that the lawyer should always start with binding precedent on a particular issue, but they can focus on the plain meaning of relevant text. Given the facts of a particular case, show me how someone reading the text would have understood it at the time that it was written. And you can go to, the corpus linguistics that's going on, seems to be something that's prevailing right now. FedSoc had a webinar on it last week, actually. So there are ways to do it that way. What I find is least persuasive, at least in my view, is when attorneys spend most of their argument or pages and pages in their briefs discussing legislative history. And when I say legislative history, I'm talking about committee reports, staff analysis. I'm not talking about prior enacted statutes as some way for us to divine or derive what the legislative intent was behind a particular statute, because that's not what's of interest to me. I mean, if Senator Cruz is giving a floor speech about his view on a particular bill, it may tell me a little bit about the way Senator Cruz feels about the bill, but it doesn't tell me anything about the way another senator or the president, or in the case of state, what the legislators or the governor thinks about a particular bill. So in terms of providing arguments to the court that are going to be relevant and are going to be useful for us in deciding, or useful for me in deciding a particular case, it's best to avoid long drawn-out arguments on legislative history, which I just don't think is authoritative or persuasive.
Yeah, that's a good transition for something I wanted to ask Judge Gilman, and that is, so with this understanding of textualism, is there any situations in which you encourage lawyers to take a non-textualist approach in arguments they bring before you?
Well, I mean, a lawyer is primarily bound by the ethical rules and has to zealously represent their client. So, you want to know your judge, and I think there are more judges now who are really looking at textualism as something that's important and, very binding on them. But I think if there is binding non-textualist case law that would apply to the facts of their case, they're duty bound to present that to the court. And, in presenting that, if they point out the fact that, yes, this may be binding, but it's not based on the text, and they may think it's incorrect, something of that nature, I think that would be appropriate at that point to present that to the court. Additionally, especially on the court on which I currently sit, it might be appropriate in the case of if your case doesn't rise and fall on the interpretation of a word or phrase. You've got some other issue at hand, then making a textualist argument may not advance your cause. It may not be relevant. And in that particular case, then it would certainly be appropriate to make a different type of argument with the understanding that the court is going to follow the law, but it may just be a different approach that applies.
Okay. So let me ask you this. I mean, I think we have a general understanding of the dangers of relying on legislative history, and Judge Barrett and Judge Berger, outlined some of that. But help me understand how you would view arguments that can tend to be, let's say, over literal, right? They may be myopically focused on a dictionary definition, and how would you encourage lawyers and advise them to really, when you're looking at text, to incorporate the context? What does that mean?
Well, context is a primary determinant of meaning. As Judge Barrett pointed out, words really get their meaning from other words that they're associated with. So if you're just looking down at that one word, that may give you, it may not tell you anything about the issue at hand. So, and speaking about canons as well, the whole text canon tells us to consider the entire text in view of its structure and of the physical and logical relation of its many parts. So if you're looking at a word in the context of the chapter as opposed to just in a minute little portion of it, that's probably going to give you only one reasonable explanation of what that term means. Whereas if you were looking at it in isolation, it may look perfect in isolation, but when you compare it to the entire part, it may be contradictory in other portions. So I think that there's a bit of a danger there of creating ambiguity or confusion, and you're not giving it its ordinary meaning because you don't really know what that is unless you look at it in context.
Okay, good. All right, so let's go from there and get into our second topic, which is originalism. Something that Judge Gilman knows is when the governor interviews people for judgeships, and he interviews, every person he appoints. He often asks the question of, hey, tell me what your judicial philosophy is. And sometimes people will say textualist, sometimes they'll say originalist. Both of them are good answers. But sometimes there's a lack of understanding of the difference. So let me turn to Judge Barrett, and can you explain to us a little bit about originalism and its distinction, or maybe the ways that it works with textualism?
Sure. I mean, I think textualism and originalism have similarities. I mean, I think most who identify themselves as originalists in constitutional interpretation also identify themselves as textualists in statutory interpretation. And so when I identified the two primary components of textualism before, I said that it was that a text is interpreted consistently with its ordinary meaning at the time of enactment. And those are the criteria that most originalists agree applies to originalism, that we interpret the text, say, of the Fourth Amendment consistently with its ordinary meaning at the time that the Fourth Amendment was ratified. So those components are the same. I think that the differences between the two primarily have to do with the differences in the text. So the Constitution is a lot older than any particular statute. So statutes, like, if we consider, a statute it's old if it was from 1964, right? But I mean, it might be the Affordable Care Act, which is much more recent. So, one distinction is that we don't have quite the time lag in looking at the language, and that makes originalism a greater challenge because we're doing more historical work than you need to do in statutory interpretation. I would say another thing is the level of generality at which the text is written. I mean, statutes are notoriously complex and long and riddled with multiple sections and subsections and that sort of thing. And the Constitution is brief. I mean, it's the longest lasting written constitution in the world. And it has survived as long as it has for many reasons. But I think the fact that it didn't try to nail down every detail, is widely regarded as one. And so originalism in constitutional interpretation is dealing with less text. I mean, the Constitution says less than your average statute. So I think for an originalist, I mean, you're pulling on, I mean, the interpretive enterprise is the same insofar as you're trying to glean the ordinary meaning. But let's say if you're looking at the 14th Amendment, are you thinking about what was the ordinary meaning of the word search or seizure in 1791? That's different than saying, what did people understand a particular word to mean in 1964 or in 2010? So the historical piece of it, I think, becomes a bit more challenging. And so the materials that you consult are different when you're trying to figure out what the ordinary meaning was of, say, the executive power or the judicial power. You're looking back at founding era materials, you're looking at the ratification debates, you're looking at Madison's convention notes, you're looking at a lot of materials that are just not going to come up when you're looking at a provision of the United States Code.
So that reminds me of a question that we often ask candidates for judicial appointments. Almost everyone comes in and swears off legislative history, right? It wouldn't touch it, wouldn't look at it. But then we'll ask them, yeah, but why does Clarence Thomas get to look at the Constitutional Convention notes? So that's what you're talking about here.
That is what I'm talking about. So the distinction is, in a way, Madison's convention notes, I mean, they really are. They're kind of like the secret drafting history. Madison didn't even intend for his notes to be made public. They are the drafting history of the Constitution. I think that to the extent that originalists consult Madison's drafting notes, it's because Madison was an informed user of language at the time and one who is familiar with the debates, but they are certainly not determinative. Right. So Madison, it's not what would James Madison do. It's not like, oh, this is what the First Amendment means because James Madison said this about it and he was the draftsman. Madison's convention notes should have no more weight than other sources that one might consider. I mean, one might also look at the Federalist papers and the Anti-Federalist papers. One may look at founding era dictionaries and other kinds of debates. You look at state case law. You look at the ratification debates. And Justice Scalia actually was asked this question. He participated in a panel at George Washington University later in his career. It was in the 2000s. It was kind of after his crusade against legislative history, I would say, had largely been won, that its use had dramatically gone down. And you no longer had, the famous story he tells of a brief that began, the legislative history of this statute is unclear. And so we turn to the other important guide in this area, the statutory text. Those days were over by the time, he was asked this question that you're posing about the Federalist Papers. And he actually said in this, that he doesn't object in principle to legislative history being used in that same way, as a source for looking just to see how people use language. The problem is that legislative history, especially when he first began kind of railing against its use, was far more often used as the trump card. Like, this is what it means because this is what the floor statement said, and people would pick and choose. And I think you are absolutely right, Joe, that you have to be very careful that when you're consulting founding era materials that you're not falling into that trap or using them that way. James Madison said this, therefore that's the trump card. But I think we draw on all materials that we have that indicate what a word meant to ordinary speakers of English at the time of the ratification.
That's great. All right, let me turn to Judge Berger. So I've got two questions for you. One is just a level set. So when you're doing statutory interpretation, are you always starting with ordinary public meaning? Is that really where you begin the process?
In statutory interpretation, I think when we start with the text, and then from there, what did that text, what did a reasonable person reading that mean it to be at the time that it was written? I mean, words, context certainly is everything, and words tend to mean to the general public different things over time. For instance, the word viral, if you said something was viral 50 years ago or 100 years ago, or shoot, even maybe, earlier than that, most people would think it was, a disease, or you're talking about some sort of illness. And of course, today with COVID, we might be thinking the same thing. But now when you refer to something as viral in the age of the internet, it can mean something totally different than a disease. It can mean it has spread rapidly throughout something, is in modern day is spreading rapidly. A picture, a photo, an act, something is spreading across the internet where it's being seen by everybody all over the world. So that's why it's important to look at the text and construe it based on what those words and phrases meant at the time that it was written. And then we can apply things that are before us today to what it meant at the time. So that would be my answer to that question.
Yeah, okay, so with that approach, let me ask you, if you look at the text, you look at the context, and it's absolutely clear to you, are you comfortable as a judge, or are you even comfortable with litigants, lawyers who are before you, just stopping the analysis right there? Or do you expect them to move on, double check it in the dictionary, or some other place?
I am a fan of brevity. I think that if the statute is clear and unambiguous, you stop. Now, I have in a dissent before, when I was on the Fifth, I have defined a term that was clear and unambiguous to make a point. And the term was all in dealing with exculpatory clauses. When you waive, an individual signs a release and waives any and all claims whatsoever. And my point was that it also encompassed claims of negligence, even though negligence was not listed out specifically in the exculpatory clause. And at the time, the Fifth DCA was the only DCA in the state of Florida that didn't require you to specifically waive acts of negligence. So my point in defining that term, my purpose of pointing it out was I knew that this was going to be reviewed later on. The Supreme Court was going to have to make a determination on conflict jurisdiction. And so I defined the term all to make my point that all included everything, including acts of negligence. So I think there's a time and a place to do that. But in general, I would say that if I'm looking at a statute and having to determine whether it's clear and ambiguous, that it ends if it is, in my view.
Good. All right, Judge Gilman, let me ask you, when you are conducting textual analysis, in what way is it informed or even altered by case law? I'm not talking about the situation of, some clear, on-point, binding precedent, right, that you've just got to apply. But in the fact that you can look at the text, you're trying to understand it. To what degree do you want to hear case law from lawyers to inform how you read the text?
Well, I think, if there is case law that has already interpreted this word or phrase, I do think it's appropriate to bring it forward. But it really depends on how the case analyzes the text. So on one hand, if you look at the case and it's interpreting the same phrase, it can be helpful in a sense that, if they're performing the same analysis that you would have performed, and that's sort of laid out in the case of how they came to this particular conclusion, then sure, I think it can certainly be informative. But on the other hand, if the case instead provides no explanation of how they arrived at this explanation of what this term means, or if I don't agree with the analysis, if I think they pulled something from legislative history and they imputed this definition that seems technical when it should have been ordinary or something of that nature, then I would look critically at it. But it's certainly something that I would look at.
Okay. And speaking of case law, it's always good to leave one of these webinars with a good assignment. So is there a U.S. Supreme Court or Florida Supreme Court opinion on this topic that you would suggest the audience go and take a look at?
I think Dickerson versus United States is a really, nice example of sort of, some disagreement within the court of, first of all, what was a holding? I think that's always very important to look at. And I think, what really matters in how a term is interpreted subsequently.
Okay, good. All right, well, let's roll into our third topic here, which is the role of stare decisis. And we're really looking at that in relation to textualism and originalism. So let me just return to Judge Barrett and say, what should a good textualist and a good originalist know about stare decisis?
See, I mute myself there. Well, stare decisis is an independent body of law. Itself is doctrine. It is doctrine. It is law. So in the Seventh Circuit, we have a law of stare decisis. We have practices that one panel can't overrule another. We have to go en banc or decide as a full court if we're going to overrule something. And we certainly lack power to overrule precedents by the Supreme Court. So I think that it's one thing to sit down and tell a good originalist or a good textualist how to interpret, say, the Fourth Amendment from scratch, something that, say, like an academic in my old life, you have the luxury of doing, of just sitting down and saying, what is the best answer to this question? But the reality of litigation on the ground and of judicial decision-making on the ground is that you're working within a body of precedent. And so, judges, I hope I'm a good textualist and a good originalist, but I don't have the luxury of starting each question from scratch. There is a lot of law that governs, a lot of law from the Supreme Court. I've only had one constitutional question in my time on the bench that didn't have governing case law from the Supreme Court. So I see a lot of constitutional questions, lots of due process clause questions, First Amendment questions, that sort of thing. But there's always a governing framework. I'm not kind of going down to the studs. I always am bound by Supreme Court case law that I'm taking. So I think especially when you're talking about lower courts, you're not, as a judge, going to have that many opportunities, especially in constitutional cases, to interpret words for the first time. A Second Amendment case that I had was the exception to that because Heller is so recent and the court just doesn't have a lot of Second Amendment case law. And so that has left lower courts in the position of confronting the original meaning of these terms in the Second Amendment for themselves.
Yeah, now that makes sense in real life. In our judicial appointments process, we have the luxury of coming up with hypotheticals, right? And so we often put people in these, impossible situations. And so let me just kind of throw a general one out to you, which is, what happens if as a judge, you're looking at a statute, there's a clear textual, answer to this, there's the interpretation to this. It's beyond a shadow of a doubt. You're ready to go. But then you're presented with precedent that is the opposite, and it's wrong. So as a judge, what do you do there? Are you bound to in some way respect the legislature because you can clearly understand the statute, or are you bound to follow this binding precedent that even though you think it's wrong, it's from a higher court? How do you grapple with that?
Thanks for putting me in the impossible situation, Joe. Well, in the Seventh Circuit, we have a procedure that's unique. As far as I know, no other circuit has it, and I think it's very valuable in that kind of case. It's called Circuit Rule 40E. And so the rule in every circuit is that one panel can't overrule another, but, 40E allows a panel, and I have had this situation in statutory interpretation questions. If precedent does seem that squarely wrong, you can circulate the opinion to the full court internally before it's published, seeing if your colleagues are willing to overrule the precedent and kind of laying out your case for the statutory interpretation that you think is correct. So, you have to get everyone to go along. You can't have every man for himself because that's not a way that you can run a court. But our process of Circuit Rule 40E does provide a mechanism for the court reconsidering more easily, I think, than in a system without Circuit Rule 40E, whether we want to leave things on the books that really do kind of seem that far off course.
So now, every good hypothetical can be adapted. So we would say this is U.S. Supreme Court precedent here you're dealing with. But, I guess just one last question on the topic is you referenced that precedent is law, U.S. Supreme Court precedent's law. Like why is that? I mean, I think some people do struggle with the idea that the lawmaking authority passed this absolutely clear statute. And why, as a judge or a lawyer, am I bound by this U.S. Supreme Court precedent that I think is clearly wrong, right? That was decided decades ago with a purposism type of approach. Why am I bound to that?
Well, in our system, one rationale that people have offered for vertical stare decisis, which is the obligation of lower courts to follow Supreme Court precedent, lies in the statutes that Congress itself has passed governing the appellate structure. And because the Supreme Court is the court that sits at the top of the judicial hierarchy, and it is statutes, that have put it there, there are always going to be disagreements, and Congress knows that, which is why we have an appellate process to begin with. If we thought there would be no disagreements, then we wouldn't really need to have anything but, first level trial courts. Everything could be resolved there. So I think that the conventional answer to that is to point to the statutes that create our hierarchical appellate system and say that Congress vested, by virtue of the appellate process, the final word on individual cases with the Supreme Court. And so that lower courts, because of their position in the hierarchy, have no authority to supersede that. Great.
All right, let me turn to Judge Berger. No impossible questions. Just want to hear from you. Your experience moving from, an appellate judge to a trial judge, what's it like in terms of maybe being on the other side of stare decisis, having to have your decisions, always influenced by the higher court?
Well, it makes it easier. I mean, obviously, as a judge, if you have case law that's directly on point and knowing that you have to follow it, it doesn't necessarily mean you always have to agree with it. But the way our system is set up, we are bound by the appellate court decisions. And for me, the 11th Circuit and the United States Supreme Court. When I was on the Fifth, much like the system with Judge Barrett, if there was a case out of our court that we thought that I thought was wrong, or another one of the judges on our court thought was wrong, we would go to the entire court and see if everybody was willing to change that opinion and reverse course. And so there was a method for doing that in bank, and we certainly had the ability to do that on opinions and precedent out of our own court. We didn't have the ability to do that in the Supreme Court, but stare decisis in that sense is important, because I do believe there should be finality and there should be predictability in the law, but not at the expense of it being wrong. And so I think there's a mechanism to change it. I don't have that authority as a trial court judge. What I can do is analyze the case and use the precedent, decide the case based on precedent. But I don't think there's anything wrong with especially in the terms of the context we're talking to today in textualism and originalism, is indicate or write something that if I were writing on a clean slate, I would reach a different result because A, B, C, D, and E, which may invite a higher court to rethink the way they approach the law or take another look at it. And I don't think that it's wrong for trial court judges to do that, because we honor our duty to follow the law in those circumstances, but yet we can indicate why we believe a particular decision should be changed. On the appellate court, you could do it in a dissent, or a specially concurring opinion in a particular case, and that's how we would typically do it. But in terms of being on the trial court, I don't have to have to convince two other people to agree with me on a particular case. So that's good. But in terms of the law, I am bound, as every trial judge is, by a higher court.
Yeah, that's great. I think that approach, when you've got to follow, but you think the precedent is wrong, and the way that you would write that makes a lot of sense. Just out of curiosity, have you had an opportunity to write that kind of opinion so far?
Not since I've been on this court.
Okay. We'll look at your old opinions. All right, let me switch to Judge Gilman. So let me ask you in general with stare decisis, is it your perspective that it is minimized when you're dealing with a case of statutory interpretation as opposed to a case of common law? Or does stare decisis just apply the same in both scenarios?
So I think minimized is, one thing, but I certainly think they're different. And when you're interpreting common law, that's, you've got a lack of positive law. You don't have the statutes or rules or regulations. The court systemically developed that law through judicial decisions because there was no written law. So judges were the ones essentially creating the law. And that's the law that they were bound to apply. So, I do think it's a little bit more maybe important in those particular situations, certainly than it would be in a statutory interpretation case. But even still, that common law precedent yields when it's contrary to reason or divine law. I mean, just because it was, there's precedent there, doesn't mean that you blindly follow that either. And let me just also use the caveat that on my court, I'm bound whether I think it's wrong or not. But I would signal that I think that it's incorrect. But so for my purposes, it's a little bit different, but theoretically. But when you have a statutory interpretation question, that's a different issue. I think the Constitution really changed that. Now it's the political branches, not the judicial branch, that's tasked with making the law. So it's definitely a different analysis. And I mean, Justice Thomas's concurrence in Gamble versus United States, I think, just does a wonderful job of explaining that and explaining the differences and the certain scenarios where it might be appropriate to change that. And, I think that with some caveats for, Florida has its own particular issues. But I think, Justice Thomas really lays out the important differences between common law, stare decisis, and statutory interpretation, constitutional law, and why, when you look at a positive law versus judge-made law, it should be different. So I think that there is a different analysis.
Okay, that makes sense. Let me just ask you one last follow-up, and that is, in situations where you have a case where you're going to decide on common law theory, as you said, it's a judge making law. Is that scary? I mean, we spend so much time talking about, the role of a judge and restraint, the judicial power, respect for the legislative branch and the lawmaking power. I mean, what's it like as a judge to feel like you're really, expanding the law when you're dealing with of common law?
Well, I think as a judge, every decision that I make feels heavy, whether it's, common law or statutory based. I don't get the opportunity to deal with many constitutional issues, but I think, you take it the same as you would in that I don't see my role as expanding the law regardless of the area. I don't want to create new rights where there aren't any. And I think too, in 2020, there are so few areas that remain truly common law that the statutes have become so broad and all-encompassing that especially on a state trial court, the majority of what I see is based in statute. But I would certainly take great pause in even considering and extending any sort of common law right that wasn't firmly rooted in some precedent.
Okay, good. All right, well, hey, thank each of you for working through those three topics. We're just going to do a little bit of Q&A. So one question we have is, there's a famous hypothetical that Justice Kavanaugh recently referenced, and it's known as no vehicles in the park. And, the hypothetical is you've got a city park, an ordinance that's posted that simply says no vehicles are allowed in the park. What Justice Kavanaugh said in raising that was, no good judge would prohibit a mother pushing or parent pushing the baby stroller through the park, right? But if you look at a dictionary definition of vehicle, it's a thing that transports people or goods. So how do you reconcile that? How do you reconcile a clear dictionary definition, in this case for vehicles being a thing that transports people, which a baby is, in the stroller, versus common sense, or maybe there's something else going on that you should be analyzing? Anyone want to take that one up?
I'll take that one. So that is a famous hypothetical, and I use that in my statutory interpretation class. I would say that, yeah, it depends on context, and the court has said that in other contexts. I can't remember if Justice Kavanaugh referenced this case or not, but the Nix case deals with the word tomato and whether it's a fruit or a vegetable. That's one of the famous ones like this. I mean, botanically, a tomato is actually a fruit. I think my children would be devastated if it didn't count as a vegetable on their dinner plates. So I think there are some words that in context mean a certain thing. And actually the vehicle thing comes up. Some of the hypotheticals that I use with my students are different jurisdictions have to deal with, is a motorized wheelchair a vehicle for purposes of DUI laws? What about a bike? There are all kinds of, actually in Austin, horses. There were the guys and horses in downtown Austin who got charged with DUIs. So I think, in real life, it's not just a hypothetical, that vehicle question gets played out. And I think it depends, on the context, but we are considering the ordinary meaning and not just the hyperliteralist dictionary definition of vehicle that would be taken in isolation.
Good. Any other thoughts on that?
I think it comes down to the difference between, are you a textualist or are you a strict constructionist? And those are two different things. Are you looking at the literal meaning of the word vehicle, or are you looking at, what a fair reader of this ordinance would have understand the text of it to mean? And I think that a fair reader that looks at an ordinance, says that no vehicles are allowed in a park, would not think to themselves, that means that I cannot push my baby stroller in the park. And so I think it depends on where you fall on the spectrum, how you analyze this particular statute. But I think Justice Kavanaugh's point is reasonable.
Okay, so that leads me to a second question we have, and I'm going to go to Judge Gilman for this, and that is, after this U.S. Supreme Court term ended, defining oneself as a textualist is a little more tricky based on the case that we got during that last month. So what's your response to someone who says, hey, explain to me your judicial philosophy, or label your judicial philosophy in a word or a phrase?
Oh, man. All right. Well, I think that the labeling is always the most difficult for me. My philosophy is that a judge should exercise their role as defined by the Constitution and to state what the law is and not what it should be, And doing that requires a dispassionate analysis of the law that was actually enacted. So again, not the legislative history or things that didn't actually make it into the law. If I've got to come up with a word or phrase, my goodness. A fair implication textualist, I'm not sure.
Yeah, I think we're all coming up with these. At least we're trying them out. I've been using contextualist, textualist.
Oh, that's catchier. I like that.
All right, all right. Judge Barrett, Judge Berger, you have one. Pat, jump in.
Well, luckily, I will never be a judge, and I hope I don't have to advocate anymore. So I would let the real judges decide how they would describe their judicial philosophy.
I think Pat's saying he's a retired textualist. All right, we're going to move on to one other question. I was going to turn to Judge Berger for this one. Severability has become a bit of a hot topic, particularly at the end of the Supreme Court's term. So what are some considerations you have when faced with a severability issue on respecting the lawmaking power, but still conducting your obligations in your judicial role?
I think we're talking in terms probably of when there's the absence of a severability or non-severability clause. What does the court do in that circumstance? And if faced with a situation where a portion of the statute is determined by the court to be unconstitutional, the question needs to be is if the remainder of the statute can stand on its own, should we let it? And I think that's the main point when it comes to severability, and that there should be a presumption in favor of it, to removing the offending portion of the statute and letting the remaining parts of the statute that are constitutional remain. Because what I think that does is it avoids the judge engaging in judicial policy making, engaging in legislation. It respects the legislative process. And comports with our system of separation of power. So I think that's sort of the framework I think I look at in terms of severability.
Good. Any other thoughts on that? No? Okay. So I've got the ability to look at this question and answer box. And one, I wanted to tell you, there's been a number of comments that have just thanked you for participating here. So I wanted to pass those along from many of our viewers and listeners. I just was going to pick up one final question, and I'll ask Judge Barrett this. It's really about someone who's either a prospective law student or a beginning law student. Other than, advising them to go to Notre Dame Law School, do you have, any advice for that, perspective or kind of first year student?
Yeah, what I see in learning to think about the law, there are a few pieces of advice that I give. I mean, I think in learning how to think about the law and relevant to the conversation that we've had today, I suggest that they read A Matter of Interpretation, which is Justice Scalia's book. That is very accessible even to non-lawyers, and so I think that can give them a good foundation going in. And then there are other kind of less highfalutin theory kind of things that I tell them to do. Like, for example, I think legal writing is so important, and it's difficult to kind of pick that up and the whole thinking like a lawyer thing right on day one. So, there are several books. Ross Guberman has some just about how to write like a lawyer, and those who can write, when they enter law school end up performing better. And so I really encourage them to also kind of think about their legal writing skills in that summer before law school. But just for thinking about the law and a foundation, I think it's hard to beat A Matter of Interpretation.
That's great advice. All right. Well, I'm going to turn it back to Pat to see if he's got any closing comments for us. But again, thanks to all of you for being here and giving us your time.
Joe, thank you for moderating, and to our wonderful panel. I can access the question and answer box as well. And Joe's right. The praise and my text messages keep, buzzing and telling me what a great job the panel did. So I really can't thank you all enough. And one thing I failed to mention in the introduction is the Florida chapters have an annual convention. I think this is going to be the 7th iteration of that at the end of January, assuming we can all get together. And Judge Barrett had graciously accepted the Florida chapter's invitation to come and speak. So if you like what you saw here and you didn't have a chance to take one of her classes or 2 of her classes, you can hear her again. And then she didn't know this, but this webinar was an addendum to the request. So I'm just so grateful to all of you. And like I said, we should do it again, and hopefully in January. So thank you all very much.